Ladies and gentlemen, welcome to Agricultural Subcommittee, Subcommittee number 1. Senator Stewart?
Yes, Mr. Chairman, members of the committee. I have Senate Bill 1725, and I'll explain to you what I'm trying to accomplish. I know there's been a little bit of discussion about this bill. Y'all maybe have gotten a few emails on it. So I want to explain to you what I'm trying to do, and I even have some additional thoughts about this. So I don't know how much you all know about duck hunting other than probably Delegate Knight and Delegate Bloxham and you as well.
I lived on the bay.
Okay, so in what we have is a situation where if a riparian owner puts up, and let's just call them keep-away blinds because that's pretty much what they are. You don't have to hunt in them, you just have to intend to hunt in them when you build them, and people typically probably don't. You have to stay 500 yards away from that in each direction, you know, and everywhere. If you don't put up those or you miss your opportunity to put up that riparian blind, then the non-riparian owner can come along and put up a blind. And what at least a lot of us see, and I've had 2 constituents who have been faced with this situation in the recent past, they did not put up a riparian blind, and someone came and they put a stake in one case on either side of their house and right on the shore. And we call these offshore blinds and offshore stake sites. And so actually in talking with one of the game wardens a while back, trying to figure out a way to resolve this conflict, because that's what happens. The person puts, in this case it was 2 offshore stakes, and the guy's house was there on the creek, and he put the stake on one side of the house there and one on the other side of the house. And so when he wants to hunt, the people in the house are just aggravated, and they go ahead and they do things, and it's just a conflict that I'm trying to resolve. And so honestly, what I did was I sat down and thought about it, because as we looked at this, we said offshore blind stakes. So then why shouldn't they be offshore versus on the shore? And I came up with 150 yards because I don't want you shooting at me with steel shot any closer than that. And that's honestly what it was. Steel shot, unlike lead shot, will flatten out. It doesn't have the velocity and the distance that steel shot has. And so we picked a number out of thin air, and that's the truth of it. The lethal range of steel is probably 70 or 80 yards, and we went to what we thought was a safe thing. I know that it's created some consternation with folks, and I truly believe that this may resolve some conflict. And if people had to stay off of people's shorelines, that some of these folks would stop putting up these keep-away blinds. And under this bill, you still can come up on the shoreline if you want, if you just get permission from the person who owns the land. So I was trying to work through it in such a way that I thought it was reasonable. We see more and more of this all the time, and I'm just trying to get to a place where you, as a person who owns property on the creek, has a house and a dock and wants to enjoy their yard, but may not have put up a keep-away blind or their own blind, is not infringed upon by the person who wants to hunt, but also the person who wants to hunt can hunt. And I know there are issues about creeks being too narrow, and there are all kinds of things like that. So actually, and you know, I don't know y'all's inclination on the bill. I know there's been a lot of discussion on it and emails. I thought about things like maybe we could amend it to say 150 yards from a structure, because that's what you're really trying to get at, and then maybe 50 yards from the shoreline if there's not a structure. But the issue we have is literally people, and it's not people who live in the areas that are hunted, it's people who are coming from long distances and finding spots, but they literally are setting up right by people's houses, right by people's docks, and it keeps them from being able to enjoy their property. So that's the bill. You may not like the way I'm trying to get at it. I've had some other thoughts about ways to get at it, but it, you know, it's a tough one for me because I'm an avid duck hunter. But I always get permission from people, and frankly, I'm not gonna go sit by somebody's house unless they tell me it's okay. I mean, it just really bothers me, but people do it all the time. And, you know, for me, it's an issue of property rights, but as a hunter, I wanna be able to hunt too. So I thought this was a fair compromise.
Any questions from the committee this time? Yes,
Well, and maybe, Senator, maybe you and the department, I guess, Senator, to your point, totally get the problem. And right now, the circumstance is, if I'm the riparian owner and I put the blind out there, whether I use it or not, nobody else comes in.
500 yards.
So I protected
500
mine,
yards.
or I can lease it to somebody and have the same effect. On any given year I don't do that, then it's an automatic forfeiture.
Correct.
I guess my question, is there a way that before someone can just automatically come in, and the department would have these records, or i.e. where the riparian owner has right of first refusal, i.e. he puts it in this year.
They do. But
Well-
sometimes riparians don't do it or they miss it.
But I guess what I'm saying, so I didn't put it in this year, my permit lapsed, and now it's fair game. Before someone can just automatically come in and jump the claim, for lack of a better way to put it, that there would have to be an offer to the riparian owner and a presumed, if you don't respond within 10 days, then you're forfeiting your right to this. Do you understand what I'm trying to parse the baby here?
But it gets much more complicated than that.
I was afraid of that.
Mr.
It
Chairman,
sounds like
if I
more of a
may.
lawyer thing, I'm
And
sorry.
so here's what happens a lot of times, and Tom's probably here. What happens a lot of times, you'll see a riparian put up a blind, and it may not be the best blind in the world, and they may not have
Right.
checked on it. And somebody comes along and says, well, I didn't see that blind there. And so as the non-riparian, they put up a blind. Well, then it becomes a fight. And it's not the game warden, conservation police officer, I'm sorry, I'm used to calling him game warden, not the game warden's responsibility. It's yours in a civil court. And so your whole hunting season's fouled up because of that. And so I thought about what you were talking about, but I really am trying to establish some line where each party can enjoy their rights, I guess is what I'm trying to say, both the landowner and the hunter. And it's difficult, there's no doubt about it, it's difficult.
Senator, I know that, I know what you're saying about that. I totally get it and everything. We've always given preference to the riparian owners in here. I do know that when we had these blind licenses in Virginia Beach that were always handled in Virginia Beach, and then when they started being handled in Richmond, we had a lot of conflicts in there. And we did give a year's grace period. If someone didn't build a blind one year, we gave them a year's grace period. And you know, it may be too late to fix your bill this year, I don't know, but if you have a riparian owner that has a blind up there and you see when the blind was issued, then I still call them game wardens in reverence, but you know, the game wardens know that they were first. You know? but they know they were first, they know that, but if they miss it one year, then they ought to have maybe a year's grace.
They do get to come back up next year. So the riparian owner always gets the first shot every year.
Right.
At getting it. The conflict comes in, and I don't know any other way to describe it, but what you see now is you see people coming in and putting their blind, typically it's the float blinds, right by somebody's house. In some cases, members of your body have had them right in their front yard. And pretty upsetting to them. Now, and I was aware of that one as well, but this last situation, it was on either side of the house, and we were able to resolve that for the constituent, but that's the conflict I'm trying to resolve. There's gotta be a way, even if we just amend it from a structure, so that people don't get so close to somebody's house.
Delegate Bob.
I have a question, I guess, either for DGIF or not. Are these blinds, because we don't do it on the Eastern Shore, are they licensed to a person with a GPS coordinate? Is that how that's done?
Yes.
Okay, so then I actually have an area, is it on a map that I can actually go on and see an area that
Yes.
where a blind is and where I can go?
You have to give the GPS coordinates to DGIF in order to obtain the license. But DJF, because the law doesn't require it, they're not looking on the map going, well, there's a house there, you can't put a blind there. You see what I mean?
Right.
There's no provision.
Understood. I'm just trying to get the whole layout of the way that works, because we, thank goodness, we're written out of this section of the code.
For flood lines. For flood
I think the
lines.
Eastern Shore is written out. Yeah.
Okay, if you have a pressing question, go ahead. We're gonna hear testimony from the public and then Judge Robin.
I was gonna say, I mean, what I'm really struggling with, I feel like we're already giving a lot of rights to the riparian owner by giving them preference. I mean, if you buy a house in front of a piece of land, you understand that the low water line and beyond is public access. So I think to go beyond that, we're really pushing, you know, our common law here in terms of giving more access to that, to the, you know, the public. That's the whole point of when you buy a piece of land on the water, you understand that there's public access. I think maybe you're talking about structural issues, and maybe we're talking about working on, you know, regulating the lines here and how they're maintained and all that. I think that's a different topic than what we're talking about here, because I think we're really intruding on public access, you know, past the low water line. And I think that's pretty sacred about
Is that a question or
the public
statement?
comments.
I think it was a statement.
Well,
It's
if it's a question, I'm not trying, all I'm trying to say is give these people a safe distance between the house and the blind, so that the people in the house enjoying their front yard don't have to lose their ability to lose the use of their property because somebody's shooting at there, which makes people nervous.
Yeah, but Mr. Chairman, I mean, we have already given them preference. We've already given them priority to have those rights first. And to make any changes to that, I think would change, you know, what we have right now in terms of the public comments, which is the basis for really national and international water laws.
It just, it depends on whether you support property rights or not. And I'm a property rights guy. I believe that everybody should get to use their property. And if you allow them to come, if you allow me to get so close to your property that I infringe on your ability to use it, then you're denying me my property rights. And that's what I'm trying to resolve that conflict through this in sort of a fair way. It's the best way I can explain it.
Let's hear testimony from the public. Anyone here wishing to speak in favor of this measure? Okay, is anyone here wishing to speak in opposition?
I had planned on
Okay.
speaking to this bill, but I was here for another reason today, same as I was when I heard about the bill the first time in the Senate. I'm Russ Perkinson. I'm a riparian property owner in Middlesex County. And I think what the senator's doing in some form makes sense. There's a duck blind off my property. It's pretty close to the property. I don't even know who has it. I realize I could go stake a claim to it every year, and I'm probably willing to let them put the blind somewhere off the property. It's just I feel like I ought to have some say in where that placement is. So that's my only thought.
Thank you. We're gonna hear testimony from opposition. We're gonna kind of keep it kind of short. We're gonna give you a cumulative total, so anyone in opposition? Yes, sir.
Yes, sir. It's good to see you all again. I was here a week or so ago, and I appreciate the fact that you unanimously tabled it. I'm Dwayne Adams. I'm from Louisa County. I'm not going to go through everything I talked about before, but the senator just made a great point on why not to do this. He said, I've had two constituents. You all have had literally hundreds and hundreds of emails and phone calls. I know that for a fact because I've talked to a lot of those people, and I would compliment the delegate here who talked about this is public water. I'm a waterfront property owner. I have no more right to tell somebody to build a duck line in front of my house as I guess next I'll stop them from fishing or skiing or some other activity in the public water that may inconvenience me. I'm a member of the Board of Supervisors in Louisa County. I'm a huge property rights advocate. My property rights end at the end of my property. There is nobody, and you're also discriminatory. This is a discriminatory bill. Because if I'm a deer hunter, there's no buffer to the side part of my property. You're discriminating against waterfowl hunters. So you can take this property rights argument if you want to parse it this way over, according to the senator's own testimony, a couple constituents versus thousands of duck hunters that you're going to negatively impact. And I appreciate the fact of your comments, and I hope you all continue to have the same attitude you had about this about a week and a half ago when you unanimously killed it. Thank you very much.
Thank you. Yes, sir.
I don't think he likes my bill.
He's not the only one, Senator. I was here the first time. My name's Teddy Carr, Chairman. Members, thank you for letting me speak. I'm a small business owner. I run a waterfowl guide service on the tidal Potomac River. I basically got 3 points. I'd like to ask the Senator, who's going to pay me roughly $2,000 to move all my duck blinds? It's 12 of them. Who's going to pay me to put up the new ones and take the old ones down, move them out 150 yards? I'd also like to ask the Senator that the 600 people that we take out every year duck hunting, they don't have access. That's what this is about. It's about access. It's about public access. So you're not just interfering with it's just not about property rights. It's also about people who run small businesses on the water. Mine being a duck hunting business, who take out 600 people a year. Now my ability is being hampered to be able to run my business, who denies those 600 people, half of them, 2/3 of them, whatever it's going to be, access to something they've enjoyed over the years. Those folks, a lot of them are out of state. They spend money in our state. Tell the people at Hampton Inn at Woodbridge, Dixie Bones in Woodbridge, Green Top Sporting Goods, and the list goes on of all the money that my business generates and brings into the area. Second, it is definitely given landowners preference and giving them additional 150 yards control of the water in front of their property. That is what this bill does. Make no mistake about it. What's next? No fishing, no crabbing, no swimming, no recreating, period. Slippery slope. Steel shot, I do this for a living. I've done it for 20 years. My clients are not even allowed to pull the trigger on a duck unless it's inside of 30 yards. I won't let them even shoot a duck at 70 yards. Steel shot has a very negative impact. It does not travel nowhere near the distance of lead. So I want to correct that misinformation. Also, when you want to talk about safety, just moving these blinds 150 yards offshore sets up an absolute, on the surface it sets up, everybody can see it's going to be a navigation hazard for boaters. You would be shocked at how much activity happens out on these rivers at night. It will be 10 times more dangerous moving 2,000 some structures in the harm's way of a boat. And as far as the safety, the big safety thing, Chairman, you made a really good valid point at the last meeting. Talking about when we as duck hunters position blinds, one of the things we take into consideration is ice flows and how we can position this blind to be able to keep ice from taking the blind down. The ice flows will be sometimes a quarter mile, half a mile long. No duck blind's going to stand in its way and survive. What you're going to have is a lot of unseen dangers to these blinds that are 150 yards offshore. That's going to impact swimmers, not only the boating, but then a group of family in a Belmont Bay where I hunt, the Cosby family. I can just see Neil Cosby's grandkids that range from year 8 to 18, 16, 17, 18 years old. They water ski all the time. They're not the only family that does that. I cannot even fathom a water skiing accident where one of these people, one of the kids, lands on top of these submerged pilings. It's a bad bill. It wasn't thought through. I appreciate the senator trying to work through what he's trying to do. He seems thoughtful with it, but this bill doesn't even come close to that. And in fact, he started out his presentation talking about offshore stakes. The language is non-riparian blinds. There is a huge difference between that. Thank you for your time. It was a bad bill. You tabled it the last time. I'd like to see you vote it down. Thank you.
Thank you.
It was amended to include stakes, just so you know.
All right, we'll have one more. Yes, sir.
John Colclaser, Congressional Sportsman's Foundation. Just kind of want to reiterate some of the points Jolyn made prior. Simply is actually I would submit that it's not a private property rights issue. Private property rights in that your property line, not in public waters. This is a public access issue. It is sets a bad precedent for skiers, all users of water. Just like duck hunting is a public trust resource, water is a public access issue, and hunters have 1,000 things coming down on them and impacting their ability to get outside, and it's difficult to recruit kids to the outdoors. And this is just another barrier that's going to decrease access and limit the ability of sportsmen and women to access those public waters. And I'd also like to raise the issue of the 70-yard safety concern. If that's a concern, maybe we could work that out, have some meetings with some stakeholder groups. Delta Waterfowl, National Sportsman's Waterfowl Organization is strongly opposed to this bill. You know, maybe over the summertime we can get some people together and look at those safety issues. But I can't even kill a duck at 40 yards. Can't imagine trying to kill one at 70 yards. So if y'all have any other concerns or questions, be happy to speak with you. Thank you for your time.
Is anyone here that doesn't have anything new to add? We've heard this pretty thoroughly and pretty extensively. So if you don't have any new information, sir?
Just for the record, Chris Kopak of the NRA, we stand with that.
Okay, thank you. Okay, Senator, you like to wrap up?
Mr. Chairman, as I said before, I'm just trying to figure out a way to resolve some kind of conflict. I know that, and I really was hoping for some suggestions from this committee, because the issue's not going away, and I don't want to have to keep dealing with it every year. If 50 yards is the right distance, or if we're just staying away from people's houses, but there needs to be some resolution, or the conflict's going to increase. And the gentleman, Mr. Carr, I mean, I don't know his situation, but if he's got the same licensed blinds every year, then either the landowners are letting him do it, or he's got permission, which it still allows for that in the bill. If you have permission from the landowner, you can put them as close as you want.
So I have a lot of my duck blinds around public property that are non-riparian.
I appreciate it.
And I just
Thank
bring
you.
that, because I don't know his situation, but
Sure.
you can still do it as close as you want. The idea is you just don't want somebody shooting over your yard when you're trying to enjoy your property as well.
Senator, we have as you said, we've kind of got a little bit of a dilemma here, and we really, you know, I know I certainly understand where you're coming from, particularly on the structure. You know, I own a little bit of land too, you know, so I can totally relate to you. I'm wondering out loud, in the last hour here, so to speak, with all this, I wonder if you would consider being amenable to maybe working with some stakeholders to come up with something maybe we could do next year. You know.
Sure, if that's what it takes.
Yes, sir.
As I say, the issue's not gonna go away, it's just gonna get worse, because we've got, and I think Mr. Carr said it best, we've got a lot of people that are continuing to come into to the state that wanna find places to hunt, and I think the conflict's gonna continue to grow, so I think we've got to figure out a way to deal with it.
We could, we could absolutely, we could talk to the chairman of House Ag, and I could talk to the chairman of Senate Ag, and see if.
I know him.
Yeah, I do too. And see if possibly they could write a letter, you know, to study this in the off session, if you think that sort of would be appropriate.
If you all don't like the bill, that's one alternative. Whatever you think's fine with me.
Okay. Committee, have a motion? I'd like to have a motion. Or we could,
Do you want to lay it on the table?
no, we're not gonna lay it on the table. We're gonna pass by indefinitely, or we could pass it by for the week, you know. But it's all the same. It's all the same.
Mr. Chairman.
Yes, sir.
We need to look further into this. It is a problem. I've lived on the bay. I have a little bit of it, not much up on the interior on the lakes and everything. The Senator has an issue that we need to resolve. We don't have a resolution for it. I don't think this bill really does it. I think we need to PBI it and send a letter to DGIF and see if they would conform or set up some kind of little group and look at it and see if we can get a better proposal.
We'll accept that motion. Second. Senator, you have 2 minutes. Are you okay?
Yeah, that's
Okay.
good. Yeah.
Okay. Okay, then, please cast your vote. The motion's to PBI. By 6 to 0, the motion to PBI. And Senator, we'll pass that along to the chairman.
Thank you, Mr. Chairman.
Thank you, sir.
I appreciate your time.
Senator Norman?
No, I think Senator Pike was here before I was.
Okay. No, I don't think well, he wasn't on the list first, I can tell you that.
Well, that's all right. You can
Okay.
sit in your line over there. Besides, I'm enjoying it.
Stay tuned.
Oh.
Oh, no.
Uh-oh.
Senators,
Turning the tides. this
yes,
one.
sir. Which bill do you
Senate
have?
Bill 1462.
1462. Okay.
What this bill does is places misrepresentation of animals' conditions under the Virginia Consumer Protection Act, and also, as a second clause, extends from 1 year to 2 year the length of time that pet dealers' animal history and certificates have to be retained. And the original bill had a much more robust framework dealing with puppy lemon laws that are existing on the books. There have been some cases that there have been some issues where folks have been obviously loss of pet and some extenuating circumstances in terms of expenses. A lot of those were narrowed down to just place in the misrepresentation of animals' condition, as well as the extension of the record keeping associated with it.
Thanks.
So,
Delegate Bloxham.
Question. Can you explain, so we're moving the enforcement to whom and from whom?
So you have some existing today, it places under the Virginia Consumer Protection Act under this bill for lens 19 through 20. So it would allow an Office of Attorney General.
So the Attorney General's gonna do it, not the Commonwealth
That's
Attorney?
right.
Is that what it was before?
In addition to,
That was
yeah,
before.
that's right. So it gets
His substitute's got it correct. Delegate Warren.
Yeah, to that very point. Right now, part of the problem is Commonwealth's attorney, with everything else they've got going, typically doesn't pursue these potential prosecutions. Your intent is just to give the consumer a potential other outlet. And then the other is, because I'll just remind the committee, most of this language was language I had carried last year as we put some greater restrictions on the pet shop industry. And the only change to that is just now that they're gonna keep those records for 2 years in the latter part of it.
That's right.
Thank you. Any other questions? Anyone here stand in favor? Yes, sir.
My name's David Foley with Pet World in Hampton. Basically, I'm a member of the Virginia Pet Animal Advocacy Alliance, and we appreciate the patron in this bill and working with us to change it to conform with something we feel we can support. And, you know, all the members of the Virginia Pet Advocacy Alliance, we all try to portray and give as much information concerning the animals that we sell. So I think that what this does, it allows us to prove that we are the good actors and not the bad actors that the opposition proposes that we actually are. So thank you very much.
Thank you.
Mr. Chairman, members of the committee, Pete Spodge with the VPAA also. I'd echo the gentleman's comments. Appreciate the patron working with us on this.
Thank you. Anyone here in opposition to this measure? Committee, what's your pleasure?
Move to recommend report.
Any discussion? Okay, please cast your vote.
So to Norman, that wasn't near as entertaining, was it?
Senator, your bill reports.
Thank you.
Thank you.
Bring back the
Yeah.
Oh.
Okay.
When I was a young lawyer walking around in a law firm, I hired a seasoned old attorney, very nice gentleman. I said, I'm not gonna hire you on a case. Never take a case involving a church. I'll never take a case involving a dog.
Yeah. So Senator, what's your bill about, sir?
It's still good advice.
My bill is about justice.
Oh. Buford T?
The bill, it's 1367, and it came out of the legislative agenda for James City County. And before you start snarling like a dog, it's an enabling piece of legislation which gives localities the discretion to enact by ordinance dogs running at large. I think Delegate Pogge had 2 companion bills, one of which maybe you let out, one of which shouldn't have been let out, which dealt with emotional harm. But here's what happened. Every now and then we react to constituents. Had over 92 people contact me regarding dogs running at large. And why this bill came about, just briefly chronologically. October the 12th, 2-dog pack attacked a leash pet walking with owner, killed the pet. October 17th, 3-dog pack attacked 3 alpacas, which you all have probably heard about, severely injured. November the 30th, 2-dog pack attacked 2 different individuals who were walking at 2 different sites. December the 20th, 3-dog pack attacked 2 leash pecks walking with their owner and killed them both. And so some of the folks in James City County are irritated, and their board of supervisors asked me to carry this. And interestingly enough, I worked with the dog hunting community, and they have blessed it. We tweaked it so they don't have any objection for it, because it's got the exception in there for hunting dogs, which some of you all know something about. So it says, what does a dog run in pack? 2 or more, they do it. They got to be running at large, which is a definitionary term. If they do it, $100 for fine, civil fine.
Yes, sir. You know, what you did jogged our memories on the alpacas. Typically, when they chase livestock, you can kill a dog, but alpacas weren't classified as livestock.
Alpacas were in the code.
But what we've made it this year, we think. So we understand that particular situation. Any questions, committee, at this point?
I have just one question. That's about dangerous dogs. I mean, at what point would these dogs be deemed dangerous? Does that have to go through the court? That's a question.
I know a little bit about that. I've been on the other side of this issue a few times. It has to be reported to animal control, or whatever you have in the county is animal control. Comes out, does an investigation. If they think that it is a vicious dog, they can issue a summons, and the dog owner must appear in court, and the judge will make a determination on whether it's considered a vicious dog. A vicious dog is like putting a brand of a D on the dog's head for life. I did one recently, and the owner wanted to send the dog out of state to a Midwestern farm area, and it's branded, so you have to report it to their state, but it is a judicial proceeding.
Anyone here to speak in favor of the measure? Anyone here to speak in opposition? Okay, committee, this is permissive legislation.
Second.
Any discussion? Please cast your vote.
Yeah.
Just trying to help you out.
Trying to help you out there.
By a vote of 6-0 is BBI. I mean passed.
Oh.
Thank you all for your courtesy, and to you, Will, I
This is
say.
your last dog. This is your last dog bill.
Is he your last dog?
Till the next one.
Senator Boy Scout.
You and Sproul doing
Monty, you better come up here. We're not going to say you.
Yes,
sir.
Hanging in the back.
Senator Boy Scout.
How are you all?
Fine.
Good.
Welcome back.
And you have Bill, what number?
It is 1642.
1642.
Yeah, so you might remember last year I had a bill that bans animal testing in Virginia on cosmetics and household products. This is the next step in that, first we have a substitute.
I'm going to get that before us.
Sorry.
Okay.
I'm just jumping the gun a little bit.
I'm in ag.
You bet, man. Thank you.
Move substitute.
Second.
Okay, any discussion? All in favor of substitute, say aye.
Yeah.
Okay, the substitute before us. Senator?
So these changes were
That's what-
made, I've been doing a lot of work with the Manufacturers Association and the Personal Care Products Council to address the issues that they were concerned about in the bill. With these changes, I have on their good counsel that they support the bill, which is not an easy thing to do, as I'm sure you all appreciate. Most of the changes are technical in nature. This, again, as I was explaining last year, I came with a bill that would ban animal testing and household products on animals when there are alternative methods. This is talking about selling products, cosmetic products. There is a movement to try to reduce harm on animals, and this will be compliant to some other states that have done this. I would also be open to having another amendment that removes the language on line 61, removing the language import for profit. cheaper, they're faster, they're better predictive to identify adverse human reactions, and they're now widely available and becoming more available every year. In addition, companies now have thousands of existing cosmetic ingredients with histories of safe use that have been used, and so there is an effort to try to phase out animal testing. This would limit the sale of cosmetic products with new ingredients that underwent new animal testing after January 2020. So things that are currently being tested on animals would be grandfathered in already. And it doesn't penalize retailers or customers relying on manufacturers who meet state regulation or importing existing cosmetic products into Virginia from other countries, regardless of the testing requirements in those countries. I'm happy to have you hear from the folks that have been looking at that.
Any questions of the committee this time?
Chair, could you tell us what the problem is you're trying to solve?
Yeah, I'm trying to help reduce painful animal testing that is not necessary on little critters. Because there are that science and technology have implemented tests that you can use with skin samples or in vitro samples, so that it's actually not necessary in most cases to use live animals anymore. The technology has moved and we've learned a lot, and there aren't that many new products that are being used in cosmetics. So Estee Lauder, for instance, CoverGirl, some of the really big manufacturers have phased out animal testing, and I think it's a worthy cause. I bet you could agree with me on that. Nobody wants to hurt the bunnies that we don't have to.
Delegate Orr?
Mr. Chairman, and Senator, I don't disagree with your intent. I guess my question is more to the practicality.
Sure.
So this penalty attaches to the manufacturer.
Mm-hmm.
And how would my Commonwealth's attorney enforce that against China Cosmetics, Inc.?
Well, see, that's the great thing, is that we're not talking about companies that are doing this out of the country.
All right. Then to rephrase it, Estee Lauder, who, and I don't know where, but let's say their manufacturing is in Nevada.
Sure. Estee Lauder isn't doing it, isn't using animals, but I understand.
But you're avoiding the
question.
question, I would just
Yeah.
suggest.
So it would be
Because
complaint
Virginia
driven.
law only can apply to a manufacturer in Virginia. And do we have it?
I will ask you to speak to the Manufacturers Association. My understanding about this is it's complaint driven. And just like we have provisions on fireworks or other things, we have some limitations on what types of fireworks we allow into the state, or which ones we use. It's a complaint driven effort.
I think we'll get to your point in a minute, Bobby.
I think I'm gonna know why they don't oppose it.
Okay. Anyone here to speak in favor of this measure?
Mr. Chairman, Stan Trediak, I'm representing the Personal Care Products Council. I couldn't tell from back there, I'm sorry, whether you adopted the line amendment that she suggested. I didn't think so.
You don't wanna offer it.
Which was the line? Yeah.
Well,
So I tried to break
There's
that
line
up, but we didn't get to it.
Yeah.
Mr. Chairman, it's not necessary, it's already in here.
Oh, it's already in here. Okay. Evidently, the line amendment's in the substitute.
It went in substitute, it comes in substitute. Well, with the line amendment, the council can support the legislation.
Hold on a minute.
Stan? Are there any manufacturers in Virginia?
No. There are no manufacturers in Virginia cosmetics.
No, number of products being
So,
sold and distributed in the state.
so second question, how would Virginia law impact on a non-Virginia manufacturing facility?
This, it regulates the selling of the product, not the manufacturing of the product, so.
Tell me how Virginia law would have standing to call an out-of-state manufacturer to task for a violation.
No, the line amendment. So, I don't know if I can answer that question. Delegate or not being an attorney, but the line amendment is not in the substitute, so.
Which line amendment?
The line amendment would have been on line 62. After the word authority, you would strike the rest of that language. And what our amendment would do would allow the reliance of data from non-cosmetic testing required by a regulatory body, and for ingredients that are used in other industries beside cosmetics. And this can be documented by reference to the regulatory requirement at the time of the test and by demonstrating the ingredient had a history of use in the other sector at that time. What it wouldn't do, it would not result in any new tests for cosmetic purposes and no animal being subject to testing as a result of our products or ingredients. So it wouldn't undermine the spirit of the bill. But without that particular amendment, we can't support the legislation.
But, Mr. Chairman, but Stan, let me come back to, with or without this amendment, this is only going to apply to a manufacturing entity within the confines of the Commonwealth of Virginia, so far as its ability to be enforced, from my understanding of the law. Would that not be correct?
I don't know if I can answer that.
To me, it would be like saying, if under Virginia law, we're gonna say Chrysler can't offer for sale unless certain testing procedures were not done. And they offer for sale. They don't manufacture any of them in Virginia. I don't see, and it's kind of a point, Senator Boysko, I don't disagree with the intent, but to me, this is putting things in the code that makes people think we've done something, when at the end of the day, we haven't.
Okay.
Because it's a federal issue, and unless you've got a manufacturing entity within the Commonwealth, we put words in the code that don't save any bunnies.
You done?
Yeah, I mean, explain that.
Mr. Chairman, question for the patron. If we were to adopt this amendment, then answering his question, wouldn't it, in essence, prevent a manufacturer in the future?
Well, that's true. This is dealing with the sale of cosmetics in the state. So, Virginia does regulate other products that are sold in the Commonwealth. It would be the same thing. If a product contained an ingredient that was developed or manufactured using animal testing data conducted on behalf of the manufacturer and supplier after the date, it wouldn't be sold in the state. And I go back to my example of, fireworks. We allow certain fireworks in Virginia, and we don't allow other fireworks. And we somehow manage that, and maybe you could enlighten me on that.
Let me do this for a minute. Is there anyone else here that's a proponent of this bill? Is there anyone here in opposition to the bill? Brad, are you a proponent, or?
I think I can just clarify one thing, Mr. Chairman. There is one manufacturer of a cosmetic product in Virginia, but this doesn't necessarily apply to them. But on line 47, the question of how would this apply? In our estimation, that language, the preclusion of sale by a manufacturer, is very similar to what we did with PFCs in aerosol cans a number of years ago. That we said you can't sell that. It's not that you can't make it. You can make it and export it. You can do a number of things with it. We're just saying that in this particular instance, that the manufacturer could not sell. So that's the restriction in the bill. And that's the only other relevant case I have for you is, again, with aerosol cans a number of years ago. That was about a decade ago we did that.
Is anyone else here to speak to this measure? Okay. Committee?
Well, just to your point of the analogy with the fireworks, my understanding that then goes against the individual selling them, and not the manufacturer. And the retailer in this case, still within this bill, has 180 days to sell their inventory. Versus the fireworks stand, fire marshal's gonna come in and get your stuff today.
Well, it's a more gentle effort, I guess. I would ask that if you all were willing, we would put the line amendment in so that the personal care products would feel comfortable with it. This is gonna work in progress. We've been working for several weeks in collaboration with the manufacturers and the personal care products to get it in a shape that they feel comfortable with. I know this is an
anybody wanna make that motion?
Mr. Chairman, I have a motion.
Okay.
On line 62, after authority, insert, and then strike the remainder of line 65 through 68.
Is that, let's get legal to make sure that's good.
Mr. Chairman,
Yes.
I see where we start striking after the word authority on line 62 of the substitute. And then how far would we strike?
Remainder of line 65 through 68.
Through 60.
So do 65.
Or 65.
65, okay.
Okay, so that's your motion. Is it, do I have a second?
Second.
Okay, any discussion? All in favor, that say aye?
Aye.
Okay. Now, the substituted bill as amended is before us. Discussion? Okay, Dr. Bloxham.
No, I'm still trying to, or is this a solution in search of a problem, or is this gonna be attacking the retailer selling it? I'm trying to figure out what we're doing.
I think it's a very valid question.
I mean, that's, did you understand what I said, Sandra?
I did hear what you
Yeah,
were.
I'm just trying to I'm trying to figure out
Sure.
what we're trying to solve here.
Sure.
Is this a
We're-
solution in search of a problem, or are we gonna be attacking retailers that could conceivably be caught selling a product that I guess has been on animal tested? Is that what we're trying to do here? The way I'm reading this?
Animal testing is being phased out. This
Right.
is another effort to show that Virginia is on the forefront to say that we are cruelty-free. If people want those products, they wanna know that those products are actually cruelty-free, and this is a way to show in Virginia that we are being leaders.
Mr. Chairman, question.
Dr. Morfield.
I would be willing to entertain a motion to lay the bill on the table if, obviously, this is a concern of mine, and I know that you certainly shouldn't be testing these products on animals, but personally, I think there's a lot of interested groups that are involved in something like this that may not be aware of this legislation, and if you would be in support of laying the bill on the table and maybe take that as an opportunity over the next year to reach out to them and see if there can be some type of consensus made, I would be willing to make that motion. If you're supportive of this.
Sure, hold a second. Delegate Keith.
Yeah, first of all, I know that line 89 has a clause that says this doesn't go into effect until January 1 of 2020, so that's obviously a delayed enactment to start with. If there's an appetite, we can certainly push this back another 6 months or 7 months, so that it's July 1 to 2020 instead of January 1. That way, if there are other ways to solve this problem that come up between now and next session, we'll have a chance to work on that. In the meantime, this is, as belt and suspenders, we'll have this language in place, it just won't go into effect. So that might be a way for us to address concern that Dr. Morfield raised, which is, on policy, I think we all agree that it should be a policy from Virginia to prohibit or at least encourage the reduction and ultimately elimination of these practices. In terms of how we enforce it, there's some questions that are still out there. And to the extent that this bill came out of the other body, I wonder if we might be able to take this in this house with an enactment clause that just delays the enactment 6 more months. There's an appetite for that.
What's your pleasure, committee?
I don't know what the problem is. I'm gonna move to PBI bill.
There's a motion to PBS. Do I have a second?
Second.
Okay, and there's a second. You get 2 minutes if you want to, or.
Well, I just appreciate the consideration here. I think that, as the technology improves, this is an opportunity for us to be leaders. I think everybody can agree that using painful tests on animals is something that we should move out of, and, thank you for trying to work with me on this. Certainly appreciate the stakeholders, the manufacturers, and
Just very briefly, Senator, if I thought this would affect what you're trying to achieve, I would be 110% in support of it. My challenge is I don't think it gets you where you want us to be, and it gives the citizens a false sense that we've really done something to address the problem.
It has passed in California. The manufacturers there work to make it. I respect your thought.
Okay,
Appreciate it.
please put the vote before us. The motion's passed by definitely motion passes by executive. Thank you, Senator.
Appreciate it.
Okay, Senator Mason, is he still here? Oh, there he is.
Thank you, Mr. Chairman.
Senate Bill 1413.
Mr. Chairman, no ducks, no dogs, no cosmetics,
No.
just Virginia oysters, Mr. Chairman.
Got any on you? About that. About that.
There are 3 line amendments, please, Mr. Chairman, if we could start there.
Let's get 1413 before us.
Oh.
No, I'm sorry.
No, you're right.
You're right, 1413.
Yes, sir.
That way we'll all be able to follow along.
Mr. Chairman,
Okay, yes, sir.
I have 3 line amendments, and each one modifies the same phrase, and the phrase is the public benefits.
Okay.
And the line amendments change that phrase to the public benefits and impacts.
Okay,
And
where
that
would
occurs
they be?
on line 37, line 77, and line 99.
Okay. Do I have a motion?
Did I hear that again?
Okay.
Certainly, Mr. Chairman. On line 37, after benefits, insert the phrase "and impacts." So it becomes the public benefits and impacts.
Thank you.
And the same change is made on line 77 and on line 99.
I got it, don't like it, but I got it.
All right. Well.
There's one of the members of the team. I would like to remind him of the team.
Okay. Well, hold on a minute. Let's get this amendment before us. We'll discuss it. We have the amendment before us.
So moved.
Okay, you have a second? Okay, discussion of the amendment. Delegate Blocks, do you want to make a comment on that?
I'm afraid impacts has a negative connotation. I'm trying to make sure that we're not negatively, if I'm reading this right, it's after the public benefits and impacts of shellfish aquaculture.
Who came up with that?
So, Mr. Chairman, do you want me to speak directly to the amendment, or can I give you
Just-
more?
Well,
want
if
the
it,
amendment on?
well,
Because
if it
it's part of
affects
it.
the whole, if it
It does.
affects the amendment, then tell us.
It's part of the
please.
broader picture, so let me
Okay.
just paint a little bit of picture. This is a result of a year-long effort on aquaculture, trying to bring all the parties together that have something to do with it and try to find some agreement as far as how we can weed out some bad actors, how we continue to drive oyster aquaculture in Virginia and its benefits and the industry, but landowners, people that build docks and piers. So here's the team right here. And I socialized this with the team after Mr. Perkinson and his group came to my office and said, hey, we didn't feel like we were a part of this concept. And so if you look on line 36 of those amendments, we had said, and the public benefits of shellfish aquaculture. Mr. Perkinson and his team had recently had a ruling they deemed to be unfavorable in front of VMRC. They initially came, we talked about their concerns, which had nothing to do with this bill, but led to them asking me to remove that line in those 3 places. So I went back to the team and said, what do you think? And what we put together there is that when we brought in this group, we're talking about sanctuaries, nutrient credits, environmental benefits, nonprofit restoration, as well as the oyster industry. So there are a multitude of people involved in this effort that said, I don't like removing that line. So Mr. Perkinson and his team went back and we said, no, I'm sorry, we can't do it, we can't reach consensus there. He said he was afraid that put the foot on the scale for industry only, despite there being multiple other groups. So all they ask at that point is to reference the public benefits and impacts of oyster aquaculture. So they felt like that balanced that phraseology out to understand it. Yes, in fact, Mr. Block, or Delegate Blockson, it could have negative impacts, but it would be looked upon in a fair and equal manner. That's sorry, it took me a second to get through to where the amendment came from, Mr. Chairman.
Delegate Blockson.
No, I just was curious where it came from.
Okay.
Because in our discussions, because I too was in this group for a year. You're part of the team.
You are part of the team?
I'm part, well, I was.
And he's still, and he's still on the team.
Okay, we got the amendments before us. All in favor of the amendment, say aye.
Aye.
Okay, the bill is amended before us.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, this was an effort to figure out how to weed out bad actors in this environment. And what I have tried to use as an example is if this room
is 500-acre oyster aquaculture area. We have people buying up the seating area right outside the door. You know, maybe 5 or 10 acres adjacent to. And as the tide shifts or as they need, you know, these people popping up and saying, hey, I see you're farming over on my 5-acre lease. You know, for $250,000, that's not a problem. And also up on line 19, see, we gave the commissioner some discretion because people were saying, I want my oyster lease here. It just happens to be across the channel that comes in. And so we've had a lot of conversations about dredging channels, about how to weed out bad actors. Some of that, Mr. Chairman and members, is why we've raised the fees. Because if you're gonna be in this game, this is a nominal increase, hadn't been raised since 1967, the year I was born. And so, you know, is this the best way to do it? You know, we're not 100% sure, but the team determined that this was our best approach to try to promote the industry, balance out the interest of all parties involved, and at the same time try to raise some nominal fees to get VMRC to be able to do things like surveying and be able to be more responsive to folks, not industry, non-commercial, trying to trying to do aquaculture.
Let me do it this way one time quick. We have a show of hands of who in here is opposed to this measure. Okay, I don't have anyone opposed, okay?
And Mr. Chairman, Mr. Perkinson and his group deserve a lot of credit. There were 12 of them on my side.
No, we appreciate I didn't know most of those people until 2 weeks before the bill came up. They contacted me, but we really appreciate Senator Mason working on a compromise.
Mr. Chairman, that move we report as amended.
Okay, is any discussion? Okay, please cast your vote. Senator, I know this was a long battle. Appreciate your persistence. Do we have a?
Chairman,
There we go. Okay, by a vote of 7-0, the motion moves forward, and we're gonna have to hear this, I believe, tomorrow. Is that right, in full committee? So, you know, you shouldn't. Is it with it?
It has to be tomorrow.
It's a
because
resident bill.
You, Delegate Bloxham can do it. If we have any problems, we'll call you. Yeah.
That'd be great.